Good afternoon, everyone. Thanks for joining us. I'm Michelle Dunnick, the Director of Events and Investor Relations at United Way of Southeast Louisiana. United Way together with Louisiana Hospitality Foundation and the Entergy Corporation are proud to support Phase 2 of the Hospitality Pandemic Relief Program, which provides legal support and counseling services in partnership with Southeast Louisiana Legal Services and the Loyola Center for Counseling and Education. Thank you for joining us today, and I'll now turn it over to our staff attorney, Constance, at the Southeast Louisiana Legal Services.
Hi guys, it's great to see everyone today and to be here talking about this topic. I'm very passionate about it. In short, it's why and how tipped employees are paid the way they are based on federal guidelines. We're going to get very granular with it today. I'm going to provide a portion of today's conversation for questions if you have any. If I can't answer your questions, I will have my email available if you want to type them to me, and I'm happy to do the research if I can give you general advice on the topic. But in the following monthly seminars, we'll be talking about how and why you're paid the way you are based on federal guidelines. Louisiana lacks state guidelines for tips employees and tax solutions to benefit you in the future as a tipped employee. So I'll get right into it and share my screen. Again, I'm an attorney with Southeast Louisiana Legal Services. I'm in their employment and benefit unit, and I'll have the legal aid information at the end of this as well. So today's topic, there we go. Know your rights, federal guidelines for tipped employees. And that's all going to be based off of everything we talk about today is going to revolve around the Fair Labor Standards Act. And it was put into law in 1938, but it's been amended and worked on and piecemealed over the years based on public demand and need and what the legislators determined should change over time. So some of it seems archaic and old, and some of the numbers just seem so low, right? But a lot of things haven't been adjusted over time, and we're going to talk about that. And then some things have adjusted to meet the needs at the time. So arguably, as a tipped employee myself, I worked a lot through undergrad and law school in bars and restaurants. And I'm going to say we a lot because I still identify with the hospitality industry, and I still have some strong opinions myself as someone who made $2.13 an hour. So if you catch me saying we, that's why. But in short, the FLSA describes itself as a document to provide for the establishment of the fair labor standards in employment in and affecting interstate commerce and for other purposes. So if you go directly to the act, that's one of the first lines, page 1. What does that mean? It was put in place in time to meet the needs to protect employees, right? There was a lot of lacking development in child labor laws, overtime, wage pay, things like that at the time that it was conceptualized. And there still is, but it's a federal standard that states are bound to follow unless they make their own laws to protect workers. And this includes tipped employees. So it does things like establish a minimum wage, a standard calculation for overtime pay, record keeping, which is your employer keeping track of your time and keeping a record of it. And then, like I said, child employment standards. And this is across the spectrum, right? So anything affecting interstate commerce includes federal, state, government, local workers, private sector workers. It's very broad. So it's easier to kind of explain who isn't qualified. And those are people who are like salaried admin, CEO professionals, things like that, people that like do part-time childcare that's not registered, that T99s it. So the FLSA also establishes regulations for tipped employee. And if you're a person that lives off tips predominantly, your rights and protections get a little more complicated to understand rather than those who works for an hourly wage. Arguably, tipped employees do work for an hourly wage, it's just broken down differently. So things that FLSA does not regulate that we won't be talking about today, but if it's a topic you're interested in, bring it up in the chat. I'm happy to bring you some general advice and research. It doesn't regulate vacation, holidays, severance, sick pay, like meal requests, breaks, things like that, like termination laws. I know we've gone over in the past, Louisiana being a fire will state. That's not what it regulates. It regulates The main things I addressed above. And for states like Louisiana, who doesn't have tipped guidelines, it organizes tip credit and it sets a federal minimum wage. And those two things play into a lot to why and how tipped employees are paid the way that they are. Let me see, next slide. So first, it's important to go over who's covered. I was brushing on that. It's a two-part requirement. It can be this or that. And the last or that is what really covers everyone that I was talking about. So employees of employers whose annual sales are 500K a year. And then for those who don't reach that threshold, engaged in interstate commerce. And again, that's kind of a broad brush to be engaged in interstate commerce. In short, the definition is anyone who works on or otherwise handles goods that are moving in interstate commerce is individually subject to the protections we're going to be talking about. And that's nearly everyone. To generalize. A waitress handling a credit card transaction, you're impacting interstate commerce. You're a part of that. So we see it covering most employees in public and private sectors. And as I said, it's almost easier to go over who isn't covered: executives, administrations, teachers, seasonal workers aren't as well. And if there's other acts, for example, truck drivers have their own acts, even though they're affected interstate commerce, they have their own acts, so they're not affected by this. But exempt people aren't exempt to the protections per se, they're more exempt to the overtime, which we're going to touch on, but we don't need to get granular with it for today's topic. So it has some requirements that the Act puts out that takes care of everyone that's considered a covered employee, right? There has to be a minimum wage. We're still set at the minimum wage from 2009. It hasn't changed. It's $7.25 per hour. Again, states are welcome to up that. It does do smaller things like establish food credit rights and stuff. So if an employer has a shift meal or something, they can take an hourly pay, an hour out of the pay. And it breaks things like that down. Most importantly, it goes over overtime, it goes over record keeping, and it goes over tips. So for overtime, you have to be paid at least 1.5 times the employee's regular rate, which gets complicated when you're a 213-hour employee with a tip credit, which we're going to go into. For record keeping, employers must display all of this information. Like you've probably seen those big walls with, they have the OSHA warnings over here, and then they have your federal Department of Labor guidelines that we're talking about today over here, and what your rights are. Like they have to have that posted, and they must also keep time and pay records for you so that you can go through that and make sure that you're being paid accordingly based on overtime, based on your tip share, based on a number of things when you're a tipped employee. So, and then employees that are worked on tips must be informed about the provisions that we're going to go over today in advance upon hiring. If provisions change during the course of your hiring, they need to make you aware of them. And without them making you aware of them, they can't hold you to them. And they would owe you an hourly wage, and we're going to break that down. So who is considered a tipped employee? Because, you know, we see some people get small gratuities here or there, but to really fall under the threshold of a tipped employee, under the state and federal standards, well, in our case in Louisiana, just the federal standards, your legal rights, minimum wage laws, they're a little more complicated, but to generalize a tip employee is actually pretty simple. Tipped employees are individuals engaged in occupations where it results in tipped work, right? And to fall under that threshold, the only requirement is that you regularly receive more than $30 in a month in tips, regardless of hours worked. If you work 2 hours, or you work 48 hours, or you work 120 hours that month, $30 in tips, just over that is the threshold to be considered a tipped employee. So the language they use in the Act is customarily and regularly $30 a month, which means it doesn't have to be every month that you receive at least $30 a month to be considered a tipped employee. Excluding like seasonal influx. If the only time you receive $30 in tips a month is around the holidays in December, then that wouldn't fall under that, right? That's just an exceptional month. But by and large, the minimum requirement must be met by each tipped worker on a more often than not basis. And if a tipped worker fails to meet the minimum requirement of $30 or more in tips, they won't fall out of the category of a tipped employee if it's due to their own fault or their own, I guess, volitional choices to take holiday, or if they're sick. It's kind of hard to fall out of that tip bracket because $30 isn't a whole lot for us today. So that's kind of an old number that's still there. So with this, once you're branded a tipped employee, the employer may consider tips as a part of wages, but the employer must pay at least $2.13 an hour in direct wages. So how do they do this when we have a federal minimum wage of $7.25? They do this by claiming a tip credit provision. And this is set out in the guidelines in the Act. So they only have to pay you from their pocket $2.13 an hour, and then they take the tip credit. So long as you've made enough tips to get you to that $7.25 number, the max tip credit they can take is $5.12. They can't elect to pay you $1.50 an hour and tip credit up to that to $7.25. They have to do $2.13, $5.12. That's the minimum. If your tips do not get you there, if you don't make the $5.12 to make the difference in your hourly payment cycle, they're obligated to pay you that minimum wage. So an employer who elects to do this must inform the employee in advance, as I was saying earlier, must be able to show that the employee makes at least the applicable minimum wage. And then when these, as I was saying, when these things are combined, the $2.13 and the tip credit, it has to equal $7.25, or they have to bring it to that. So employees are also entitled to retain all of their tips, except in situations where they're put in a valid tip pooling situation. And most tip pools are legal, are favorable. So while a lot of people who are lay to the hospitality industry and aren't familiar with it, they think when they give a waitress a $20 tip, that waitress is getting that entire $20. And that's often not the case. There's a back waiter or a bartender or a food runner tip out, or some other tipped employee that's in the chain of service that's receiving some portion of that tip. So just like making you aware that they claim a tip credit, your employer needs to make you aware that you are a part of a tip pool too. And there's another slide on that where we'll go further into that. But your tip credit that brings you to your $7.25, that, or your tip pool that you put into the pool, those things can't be necessarily counted against you. Like, you have to take home the money after that. It's also important to define what a tip is if we're going to split hairs today. The definition of a tip is any sum of money as a gift or a gratuity to an employee by a customer after the employee has provided some type of service. You know, I used to have some old regulars that would joke, they were like, Constance, this is a gift, not a tip. Like, don't claim it on your taxes. And it's funny, but that's not the case. And he provided a service, he provided a gift in a cash amount, either check, card, or cash. And I have to claim that, right? Whether the tip is given, to whom it's given to, and the amount of the tips must be determined solely by the customer. So we're going to get further into that. It must be a voluntary tip by the customer that's considered the definition of a tip under the Fair Labor Standards Act. So gifts other than like cash-like amounts or cash-like currencies are not considered tips. So if you're waiting on one of your regulars and he has a couple extra tickets to a football game or a show, and they gift you those, even though you're waiting on them, that's not going to fall under a tip, which is kind of cool, but it's not so often that someone throws baseball tickets at you. But anything else, anything that has a monetary value, that's cash, check, card, I've even seen people tip on Venmo. Those are gratuities you have to claim. But it bears the question for a lot of people in the service industry, what about mandatory gratuities or service fees? And we see those a lot, or I used to when I worked in fine dining. You would see in hospitality, you would see right around the holidays, you'd see a lot of private dinings come in, and they have a contract with the restaurant, and they have an agreement to pay 18% on a minimum base of some amount, or the total amount with no minimum. That's not the same as a tip. That's different. And it's interesting how it plays into it, because for the purposes of the act, these are not considered tips. Instead, they're considered a part of the employer's gross receipts, excuse me. The employer cannot count them towards the tip credit. So that tiny part of the hourly after 213 that gets them to 725, that 512, they can't count that towards the tip credit, with an exception. And I'm going to get to that exception. Typically only non-compulsory tips, like we were talking about above, gifts or tips, can be counted towards the tip credit. If you're an employee that only receives, and I mean only receives, mandatory gratuities, for example, banquet waiters, all they do is work with these contracts day in and day out, and they don't receive non-compulsory tips, like side tips, they are entitled to the standard minimum wage without the tip credit. They're entitled from $7 to $7.25 from their employer. But that's not typically how it works for those of us in the hospitality industry. If you're getting private dining parties with assigned gratuities, and then you're getting tips from regular guests in the dining room floor and the bar or the cafe, where have you, that can give you non-compulsory amounts that they decide on. Normally there's some hybrid. You're kind of getting a little bit of both. And so long as you receive the $30 minimum in non-compulsory tips, you're still considered a tipped employee. So for the entirety of your pay period for that month, you're going to be on that 213. So that's kind of the catch-all. There's a lot of fail-safes to keep the cost low for restaurants, essentially. So unless you're a strict like banquet waiter, you work for a company and there's assigned gratuities and you don't get cash tips, you're going to fall back under that tipped employee guideline and be held to those standards. So another thing that we often talk about, and that I brought up briefly, is tip pooling. And that's something a lot of servers have questions about. And a lot of people aren't privy to, lay people to the hospitality industry. So it's when tips are earned by a certain person during the period of time that the restaurant's in service, and it's redistributed amongst people in the chain of service. And it's based on a pre-established formula. God, I think mine was 5% to bartenders, 20% to food runners, back waiters, things like that. And then the rest of the tips came to me and went towards my tip credit hour. And then after that, it's lagniappe, right? I still have to claim it on my personal taxes, but it doesn't affect my employer, doesn't affect the pool. So the act does permit tip pooling. Tip pooling is perfectly legal, and it's perfectly legal for an employee to require you to tip out other workers in the restaurant based on an agreed formula. So you should walk into employment knowing how much you're tipping out, who you're tipping out, what your hourly is, and so on. So long as the employer is informed and the employees are tipping the pooling requirements. Note for employers tip credit, employees may only take credits for the tip received after tip pool distribution. So when that percentage goes away from that I made in a night, say when that percentage goes away, the remainder can be applied to the tip credit the employer is going to take. And then there's it doesn't go any further than that. They can only take up to the 512, but that's what will cover that, not the entirety of it. So if the remainder after tip pool doesn't cover the 512 and doesn't get me to $7.25 an hour minimum wage, then the employer is responsible for that $7.25. So there's a lot of interesting laws with tip pooling right now that have been kind of evolving and changing, and arguments that started, I want to say 2018, and people are going back and forth on it because it's kind of a touchy topic, because people feel like they're sharing the money they earned. And one of the biggest issues right now is tip pools with back of house, like people that aren't in the chain of service. I understand they're making the food and prepping it, but they're not in the chain of tip servers or back waiters or the traditional things you know when you think of a tip pool. And last year, the Department of Labor issued a final decision on it. I attached a really interesting article. This is being recorded, so if you want to screenshot it or circle back to it later, if you want to read further into it, they decided that employers may implement a tip pool with both tipped and non-tipped employees, back of the house, for example, people that make an hourly that's probably over the minimum wage. The only exclusion is that employers and managers can't take from that tip pool. They can't be a part of it. And the catch for the employer is that the employer does not pay the tipped employee using a tip credit. So if you're in a situation where you're tipping out back of house hourly employees from your tips, that's fine, but you should also see a full minimum wage payment of $7.25, because that's the benefit and the reward for the employer. They can elect to tip out these people off of your tips, but they also can't claim the tip credit. So, which may be beneficial in some circumstances based on taxes, like where you have a higher hourly paid out from your employer where more taxes are covered. So that's kind of tip pool and just. And then another conversation, I was talking with my friend who is a bartender and who had a lot of questions about this, it's a common question. And I have some feeling, I'll try to keep my personal feelings out of it, but what about side work and dual responsibilities? And this is another hot topic that's going to keep coming up. And it's very typical in the hospitality industry. I'm sure I don't need to tell hospitality workers listening in what side work is, but for laypersons, sometimes it's referred to as dual jobs. It's when tipped employee spends time doing work that results in tips, and other times when they're completing duties that don't result in tips, i.e. rolling silverware, setting tables, making coffee, making tea, setting up the line. I can go on. And sometimes it's hours of prep or closing work that you're doing where you're not waiting on tables, or you are about to start waiting on tables or just finished waiting on tables, and you still fall under that $2.13 an hour bracket. And it's interesting how that works, and it hasn't been teased out. It hasn't been legislated too much, but I think it's worth bringing to the table as we're starting to talk about higher wages for hospitality workers and more rights for hospitality workers. So essentially, whether your employer can pay you $2.13 for the entirety of that time depends on the non-tip duties assigned to you. And these definitions are broad, so most employers what they have you do is going to fall under them. If the non-tipped employee work is related to the tipped work, the tip credit may be taken for all hours worked. So the time you're doing your side work, so long as it's a tip producing duty, right? If it's in the chain of taking care of a guest, then that would fall under non-tipped work, but it's related to. So, and related to is broad. But if it's not related to, the tip credit may only be taken for those hours in which the tip work was performed. Other work would need to receive minimum wage or whatever standard the state has, or whatever higher wage is agreed to between the employee and employer. For example, if you're a handyman and you pick up a bartending shift at a bar, if you work the handyman shift in the morning and then you co-change clothes and you go right into a bartending shift, they can't take those hours and go $2.13 from start to finish. So it'd have to be a situation like that to be so far unrelated to tipped work. I put a note in here. The duties must be performed either during the tip producing activities, like contemporaneous with your tip work, or a reasonable time immediately before and after. And I think personally that reasonable time is what needs to be legislated on and decided on, because reasonable time isn't defined. So if I wait tables for 5 hours and then I do 4 hours of side work, is that a reasonable time? I don't think so, but it hasn't been discussed. It hasn't been brought up. It's important that these are things we consider when we get to know why and how hospitality workers are paid. There was an informal 80-20 rule, 80% of tip service to taking care of guests to earning tips, and then 20% of duties related to taking care of guests and tip service. That was never codified. It was never legislated. It was just an idea, but it does seem like a good progressive start to kind of get that conversation going. But another thing is that as a hospitality worker, even though you're paid $2.13 an hour with a tip credit, you are entitled to overtime. It's just how your overtime calculated is going to be a little bit different. And I've prefaced this before when we do unemployment conversations or slides or employment law Attorneys are horrible at math. We hate it, but I broke it down here and I checked it 3 times before today's thing. So this amount equals 725, and then it's time and a half, which would be 1088 an hour. So, and then you subtract the tip credit from the hourly overtime pay rate. So your tip credit that your restaurant is claiming is going to be 512, right? That's assuming your pay rate is $2.13 an hour. So then your overtime pay is going to be $5.76 an hour. And then you would multiply that times your overtime hours, and that would give you what you're entitled to. If you make a great amount of tips during that time, an excessive amount of tips, they can't hold that against you. They can't raise the tip credit that's being deducted from your overtime rate. Like, that is the standard base. So you can't be punished for making more, essentially. So an article I have here that's really interesting that I wanted to share, find it. Let's see. Not sure. Share screen. There we go. Let's see. I lost it for a second. Here it is. Screen share, technical difficulties. Let's see. Let me go back to it. Here we go. There we go. And what this article goes into, once I start sharing it, is that restaurant workers and unpaid wages, overtime paid claims, there's new lawsuits nationwide, because I can speak to my experience when you don't earn a check from a employer, really, you walk with your cash on hand and things like that. Very rarely am I going to log in and check on my W-2 or my weekly pay and make sure I got my $2.13 an hour for the week, or my $5.70 in overtime. But after a while, this money does add up, and it's becoming a problem across the states, and it's restaurants basically stealing money from servers. And it's happening in the corporate world, it's happening in mom and pop shops, and sometimes it's by accident because people don't understand the law. I'm not saying everyone's out to get servers, but sometimes, this is due to a lack of understanding. Servers aren't paid correctly and servers don't fight for their rights. So becoming privy to this is very important. And it falls under overtime, it falls under minimum wage, it falls under paid rest breaks, meal breaks. So I can't emphasize enough how important it is for servers to check their paychecks, check with their restaurant, check your typical algorithms, check things like that, and make sure that you are being taken care of appropriately. And then let me see, I should have practiced the screen sharing beforehand. There we go, share. Okay. So that was just something that I want to bring caution to, because when people, I think, people think we just make $2.13 an hour, so we don't care and we don't check, but there's all the reason to check, because you're entitled to $7.25 if you've had a bad week. You're entitled to overtime if you work over 40 hours in a week. So that's an important discussion that needs to really come to light more for hospitality workers. And then I'll move on to, so everything we're talking about today with the Fair Labor and Standards Act, this is a standard across the country, right? But states are also allowed to make their own laws. The states are bound to the federal guidelines unless they make laws that are more beneficial for the employee, and I'll go into that. Although, states are welcome to make their own laws, legislators are only going to legislate when there's public demand and there's a push for it. And now that the hospitality industry has I think the hospitality always has been disserved by legislators, but now that they've really been served an injustice during COVID and people are aware of how little protections they receive, it's a great time to start the conversation about legislation. It's a great time to understand why and how we're paid, how the Fair Labor Standards Act works, and to look at other states that have made laws that have served the hospitality industry better, that does protect them, that does ensure something better than $7.25 an hour minimum, that protects them against really broad tip pool laws. So many states have adopted standards for paying employees who receive tips that are different than the federal standards. In some states, you see it only being $2.75. Instead, some states you see $5.60. In some states, you see $13, $14 an hour. And that's a comparative discussion for another day. But it is a great way to see what legislation would serve your state best when your state doesn't have any like ours. So in the situation where you have a federal law and a state law on the same topic affecting an employee, the rule of thumb and the generalization is that the law that best serves the employee will, so long as it's not illegal or against good conscience, will prevail, right? So localities and states can't make the situation worse. They can only better it for you. So you can, it's kind of a catch-all, right? You're subject to the protections in the federal, but if the state wants to make something that serves the employees better, they can. So as I kept harping, Louisiana does not have its own minimum wage or tipped employees laws. Therefore, hospitality workers, our only fail-safe, our only protection is FLSA. So other states without further laws are all listed just below that. For example, Texas, Georgia, Nebraska. Some states prohibit a minimum cash wage and they set them at $7.25. And the states that aren't listed in those two categories have some hybrid or in between of that, which I found really interesting. I was researching other states for today's conversation because I was going down a rabbit hole. And some states you receive a better hourly wage as an employee, a hospitality industry employee, regarding if they give you health insurance or not. So if they don't provide health insurance, that state employer has to provide you a higher hourly wage. So it's a way to incentivize health and insurance. I found that very interesting. So to kind of go over everything we went over today, employees should be made aware when they start working as a tipped employee by their employer who claims a tip credit, their hourly wage, the tip credit the employer plans on taking, that the tip claim cannot exceed the tips employees receive, right? So they're obligated to pay you that $7.25 if you don't get there, if your tips don't get you there. Employees retain their tips unless there is a tip pool agreement that has to have a formula. So the tip credit doesn't apply unless the employers are transparent with their employees. So they can't claim that tip credit if they're not letting you know how and for how much they're doing it for. Failing to notify employees about it means employees are entitled to a regular minimum wage in the entirety of their tips. So employees can be informed orally or in writing. So I know normally when I was taking a hospitality industry job, they would sit me down and say, this is our tip pool, this is your tip out, like this is how much you'll get paid, this is what overtime is like. But generally I wasn't allowed overtime. I don't know if that's changed, can't speak to that. So legal rights and remedies. The Department of Labor or the employee is entitled to recover back wages and equal amount in liquidated damages. So liquidated damages would be assigned by the court, for example. Those are kind of an estimate. It's a lump sum. It's hard to define losses essentially in the legal world, where minimum wage and overtime violations exist. So if you're trying to pursue one of those claims for back pay, if you've been wronged by a hospitality industry-based employer, you generally have 2 years until your right to pursue that claim extinguishes or prescribes, expires, whatever you want to call it. You generally have 2 years unless the employer is making willful violations, which would be harder to prove up. So I would keep that to the 2-year understanding. And the channels you would go through, I would start with administrative procedures. Criminal investigations can be opened by the DOL, and then litigation can be handled by an employee in a civil suit. So I was going to open it up to Q&A, and I'll leave it on my information slide while we go over that. I have for Southeast Legal Services for my firm, our COVID hotline number if you're a COVID impacted person looking for legal aid. And I have the website where you can go and do an online application. If you have an employment-based question for me particularly, I've included my office number and my email. If I can give you general advice, I will. But if you have a quick legal answer, I'm a big fan of quick legal answers by the American Bar Association, posted there. And I also have a plug for next month's conversation, which is going to be with our staff attorney, Paul Tuttle, on July 8th from 12 to 1. And I think that does it for me. I see. The paycheck. Hey, Michelle, are you back?
Hey, I was just going to help you field the questions.
Thank you.
Do you see the one, how should the paycheck appear to prove that the minimum wage has been achieved? Are there certain lines to look for?
Yeah, you would see the discrepancy in your tips first when you claim your tips. So if you're claiming tips that are so low, like if you're having that many days during a pay period, that's one should flag you mentally. Like there's no way if I'm running this math based on a biweekly or a weekly pay period that I'm making $7.25 an hour, or if I'm making that $5.12 an hour to get them there from the 213, you should be able to do that math on your own, and then you can see it reflect in the paycheck. If they have to make up for it, it would be on a different bracket, right? So there would be your 213 pay, and then there would be like the tip credit pay, and then there would be overtime pay should there be overtime, if that makes sense. I mean, every employer is going to do it a little differently on their spreadsheets, but and your employer is obligated to explain it to you. So if you think there's something wrong, I would go to HR or your payroll person and say, hey, I only made this much, I only claimed this much, I worked this much, this is how the math works out, explain it to me. But it should be relatively explanatory on your check. But again, employers they're free to make their checks how they see fit. So if they're ambiguous, like for a corporate restaurant, I know my corporate checks were always hard to read. So.
Now, if something is incorrect and you took it to your owner or your manager and and they haven't corrected the issue, who do you go to correct that? Like what do you, I don't want to say how do you report them, but how do you bring that up?
You can do a number of things. You could do it a number of things based on what your goal is, and your employer should not retaliate against you. I would start internally with admin, HR, payroll. And then if they can't give you what you need, I would maybe go so far as to consider a demand letter with a civil suit. But then, because most employee-based attorneys will give you a 1-hour free consultation. You can talk to them about how you think you've been wronged and if they think you have a case and they could pursue that money against you. And then if that's you also have to consider, while they can't fire you, we are fire at will. So you have to consider that relationship with that employer, which puts you in a rock and a hard place too.
Okay. Another question is, do credit card fees come out before the tips to staff?
No, I actually lobbied for that in DC. Swipe fees, they can take up to 3% from the tip for this cost of the tip. So how do I explain it? You're bound to pay the swipe fees. If you're getting a credit card tip, you're paying the swipe fee on that portion of the credit card tip. So, which is really kind of unfair. Mm-hmm. But yeah, that's actually in the Fair Labor and Standards Act. So you are paying swipe fees.
So you are paying swipe fees out of your tip. So that's another reason why maybe tipping via cash would be better, so you don't incur those fees. Another question that we had was, can restaurants legally pay managers through a tip share pro? Like you kind of said that, but are they mandatory?
No, they should not. Managers, supervisors, administration should not receive from the tip pool.
because they're salaried.
They should
And
not.
and if you are paid like an hourly paid person, can you be mandated to be a part of, like, it's okay to, like, it's legal to mandate you to be a part of the tip share program? Like, you can't opt out?
The person that's hourly to opt out of tips?
No, opt out of tip share,
So
like
if you're
that
paid,
format.
I mean, so if you're paid hourly, can you opt out of participating in the tip pool with your hourly? If you're,
Yeah.
I mean, they can't take your hourly into the tip pool if you're an hourly worker, like a host, for example, or.
Oh, I guess I
I
mean,
don't understand the
I'm
question.
sorry. A tip.
No, I'm trying to.
No, I said it incorrectly. If you're a tipped worker, can you be required to be a part of a tip share program? Let's
Yes.
first. Okay, Sonia has raised her hand. Sonia, this was your question. I don't know if I can technically. Okay, I can allow you to talk. Here, go ahead. I'm going to ask you to unmute. I don't know if it's Sonia, you just need to unmute yourself and then you can ask your question. Oh, her audio is not working. Okay.
Feel free to put it in the chat, Sonia. Yep.
Well, I guess while we're waiting on Sonia's question or her response, another question, let's see, you already answered that one. I guess, let's see, another hand up, lower hand, okay. I think we've got all of those questions answered actually, so we'll just wait on Sonia's question or her response and we can answer that. Well, you can answer that. And I guess, are there any other small bits of knowledge that you've experienced when you were a bartender, that best practices or tips, like, not, no pun intended, but like, like tips,
tips and tricks.
Yeah, tips and tricks.
Yeah, and I've also noticed that I guess it's the type A in me. At the end of the night, I would write down my sales, I'd write down my claim tips, I'd write down my hours, and I'd keep that and track it. And every now and then I would compare it to my books. And I think just management knowing that you do that and encourages good behavior, right? If they know they have a little accountant in the room, it encourages good behavior. And it always, I mean, it helped. I did it generally to budget, but it also helped me hold them accountable when I'd work overtime and things like that. So,
okay.
But that was something I always did, to just run your math to your pay period. Included shift managers, baristas, cashiers, and dishwashers.
You see that?
Yeah, so long in that situation, that was kind of what we were going back to with the tip pool. And they just changed the law on it. So depending on when this was happening, Sonia, because I think it went into act January 2021. But managers, I know shift managers sometimes, like I've been in a server where I was a key server and I was the shift manager, but I was only making $2.13 an hour. I see your date there. When I was a shift manager, I was making $2.13 an hour. I was a server, but I was still entitled to the tip pool, even though I had extra duties, right? I just got like paid in a comp card or something silly. I don't know if that's legal, but like, that's how that worked for me. But if it's an actual salaried manager, they should not be a part of the tip pool. There was no reason for them to be a part of the tip pool. And then if they're doing something where they're including people like dishwashers, then that's a non-hourly paid employee. So if it was with the new law, everyone should have been making $7.25, but if it was with the old law, technically they could have done it without, if the managers weren't a part of it. So that was kind of the way they were trying to protect that. They were trying to cut out managers and hourly back of house, like dishwashers, cooks, things like that. So from 2021, I think it's mid-July or mid-March, I'm sorry, I don't have it at hand, but from 2021, if the dishwasher was included, everyone should have been making $7.25 an hour to participate in the tip pool at least, right? And then if it's before that, the manager shouldn't have been included. Managers are salaried employees. If it's a corporate restaurant, I would take that to corporate. I would take it to HR and tell them that managers are participating in the tip pool. If there's not an HR and administrative person, I would take it to whoever's in charge, because that's not at all fair to the tipped employees. I'm sorry to hear that. You're welcome to email me if you have further questions, Sonia, or if I didn't answer it correctly. I'm not good on my feet.
So just to recap what you said earlier about if you do not make the difference to meet minimum wage, you're a $2.13 employee, and you don't make the difference to reach the $7.25, your employer is responsible to make up that difference.
Yes.
Whatever that might be, 50 cents an hour, $1 an hour, whatever that is. And they can't hold you responsible for that at all, right?
Yeah, well, there's nothing you're responsible for if you made that little tips. And in the aggregate, they stream it out. And then based on the hourly, you didn't meet those hours by 50 cents, 75 cents. They need to make that up to you. But if you make way over, they can't say, hey, we're going to only pay her $1.50 an hour and then claim these additional tips because she made so much. So it's double-sided. So it protects you, and then, you know.
Okay.
But it kind of sucks for the service industry, because you'll have 2 or 3 bad nights and then you'll have one really good night, and it's a wash, even though there was days where you didn't work for a fair hourly, technically, you know.
So that's
how I feel.
A pay period, at least.
Yeah.
That's per pay period, whether or not you get paid weekly or bi-weekly.
Yeah.
Okay, that's good to know. If you have any other questions, just feel free to drop them in the Q&A or the chat, and we can we still have a little bit of time that you can that Constance can try and answer if it's a general question. I think this is really interesting, and it is really important, Constance, like you said. I think with the hospitality industry returning, you're hearing a lot in the news about the lack of workforce, and I think that was one reason why you and I both wanted to discuss this, was because a lot of people left the industry, and they are making $7.25 an hour and not on their feet 40 plus hours a week, and they're not going to return to the industry, and
well, they were the only essential workers without a guaranteed wage, sick leave, holiday pay. I mean,
right. So I can't really blame a lot of people for going and taking maybe an admin job position or a customer service job, and they're guaranteed they're also guaranteed the $7.25, but you're not having to
fight for it.
Exactly.
Yeah.
But of course New Orleans specifically needs this the service industry folks, because this is our backbone. This is our what we're known for.
Yeah, so, and we need them. We need them, and it's important right now when we're having these conversations about the $15 minimum wage that we talk about raising that minimum cash wage up, if not doing away with it, and having a new server wage, because $2.13 an hour is it's archaic. It doesn't pay your taxes. At the end of the year, you owe an insane amount, and in a matter of dollars for the employers would make a big difference for the employees. So the hospitality industry can't be left behind in this conversation, because it's raising the minimum wage isn't the same as raising the cash wage for the workers.
And that definitely works into what United Way of Southeast Louisiana is really advocating for, as far as the Alice family, the asset limited, income constraint yet employed person. This could be a single person. This could be a family of 4. but we have all of that information on our website, and I'll make sure to send it out to people. But it's really interesting. It's done by parish in Louisiana, and it tells you what you would need to make based on what living costs are, what food and you know, just food and bills and things like utilities and things like that, what that costs. So I think, I mean, this definitely is a great topic. It's very current, and I think that I'm looking forward to our next few seminars just because it's all about hourly employees,
Yeah.
or tipped employees specifically. So next, like
I'm
you said, next month will be about tax information for and best practices for tipped employees. So, and why you need to file your taxes. I think that was something that we really encountered when we, Jennifer and I were going through a lot of the um, applications for the pandemic relief fund, was that a lot of people didn't have their 1040 tax form. And that was one of the requirements that we couldn't budge on. You know, we had to see that.
yeah.
So we were like, file your taxes and then you're eligible. And luckily, you know, some people were able to do that very quickly. On the other hand, some people were very, like, a couple years that they didn't file their taxes. So they were, it was kind of, you know, they'd have to do a lot of catch up.
Yeah,
So
we had a lot of that too at our firm. It was just like, oh God, we have to go so far back to make any progress right now. And it's just, but, and then in future conversations, I think it'll be exciting to go over what other states are doing to protect hospitality workers and how it's working for the restaurants, because
that would be great. Yeah.
yeah,
So, well, I think we've answered all the questions. I think I'm really looking forward to next month. Please, you know, register and add any questions that you have for Paul. Paul has been with us before. He understands the format, and he does a great job at answering questions as well. And of course, if he can't answer them on the spot, he's reachable by email. And I also just wanted to plug real quick that we still have our mortgage and rent assistance program. So if you are interested, if you are in need, you can apply. And even if you're receiving funds from the city's program, you can also apply to our program as well. And that could cover up to 1 month's rent or mortgage. There's 2 different applications, so make sure you fill out the right one. In addition, Louisiana Hospitality Foundation also has the crisis grants. And then we together have grants for any workplace that runs a campaign or that has given a corporate gift. So just remember all of those wonderful resources. And we will hopefully see you next month. Thank you, Constance, for everything.
thanks guys. Appreciate
Great
y'all.
webinar.
Thanks guys.
Bye.